I know I said I was not bringing anything new to TikTok, but in light of your generosity, I said, come on now, you got to give the people something. So let's talk about the civil rights court cases that occurred that we don't talk about. These are court cases that furthered the civil rights in the 1960s and 70s and made simple things, things that we take for granted now, like the ability for Black people to be able to stay in a hotel, to eat at a barbecue restaurant. These are things that we take for granted. But back in the day, Black people couldn't do that. Let's talk about one of those cases now. Why we don't know about Heart of Atlanta Motel Inc. versus United States is beyond me, since it's a big deal. It's a big deal. Heart of Atlanta Motel Inc. versus United States, which was in 1964, was a landmark decision of the United States Supreme Court, holding that the Commerce Clause gave the United States Congress power to force private businesses to abide by Title II of the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, religion, or national origin in public accommodations. You have to let the people in regardless of race. Title II of the Civil Rights Act of 1964 applies to places of public accommodation involved in interstate commerce, such as hotels, restaurants, theaters, and motels. Now, a little background. The Heart of Atlanta Motel was a large 216-room motel that opened on September 5th, 1956 in Atlanta, Georgia. This is the South, so of course they refused to rent rooms to Black people. The owner, Morton Rolston, filed suit in federal court, arguing that the requirements of the Act, the Civil Rights Act of 1964, exceeded the authority the Commerce Clause granted to Congress over interstate commerce. The Commerce Clause gives Congress the power to regulate commerce with foreign nations among states and with Native American tribes. It also restricts states from interfering with interstate commerce. Rolliston specifically argued against Title II of the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, religion, or national origin in places of public accommodation. Hotels and motels are included as types of public accommodation in the Act, and so are restaurants that serve food substantially to those who participate in interstate travel. Rolliston also asserted that racial discrimination by an individual is not prohibited by the 14th Amendment or the Constitution. He is correct, claiming that discrimination is a private wrong that individuals are allowed to commit. He maintained throughout his argument that the Constitution should be interpreted as it was at the time of its creation and as the framers originally intended it. Well, he shouldn't have said that, because the 14th Amendment was intended to end discrimination and provide equality for all Blacks everywhere. So maybe he shouldn't have argued that. But anyways, he concluded his opening argument by stating that the Supreme Court did not need to exist if the Commerce Clause allowed for Congress to enact any regulation it pleases. So let's move on to the deliberation phase. The Solicitor General of the United States, Archibald Cox, stated that requiring adequate accommodation for African Americans was unquestionably related to interstate travel, and that Congress, under the Constitution's Commerce Clause, certainly had the power to address such a matter in law. Cox stated that racial discrimination in inns and restaurants constitutes a source of burden or obstruction to interstate commerce. Cox also highlighted how discrimination by hotels and motels hinders interstate travel by limiting the availability of accommodations for travelers. He describes the impediment discrimination imposes with a hypothetical road trip. On a motor trip between Washington, D.C. and Miami, Florida, the average distance that was found between accommodations of reasonable quality open to Negroes was 141 miles. He emphasized that the courts have consistently sustained cases that strengthened anti-discrimination methods. Lastly, he asserted that the 13th Amendment applies primarily to slavery and the removal of widespread disabilities associated with it, and so it undoubtedly would not place issues of racial discrimination in public accommodations beyond the reach of federal and state law. But surely it would turn the world quite upside down for anyone to seriously suggest that the 13th Amendment was intended to prohibit either Congress or the state governments from guaranteeing Negroes equality of treatment in places of public accommodation. So now we get to the ruling, which was very simple, really. The United States District Court for the Northern District of Georgia ruled in favor of the United States and issued a permanent injunction requiring the Heart of Atlanta Motel, Inc. to refrain from using racial discrimination when providing services or goods to guests or the general public on its premises. You have to be open to everybody. The United States Supreme Court held that Congress acted well within its authority under the Commerce Clause in passing the Civil Rights Act of 1964, thereby upholding the Act's Title II in question. While it might have been possible for Congress to pursue other methods for abolishing racial discrimination, the way in which Congress did so, according to the court, was perfectly valid. So the hotel could not discriminate on who it could and could not provide services to. Just a reminder that I am raising money for rent for March. Some things fell through. Other things are taking longer to come together than I would like. That's okay. Things will work out the way they're supposed to work out. So go ahead and click on my Linktree link. See if there are any blankets you would like to purchase, any lectures you would like to attend, and of course, I do have a GoFundMe. I appreciate any support, even if it's moral support. Thank you in advance.